I call the Honourable Member David Clendon.
Tēnā koe, Mr Speaker. Thank
Tēnā
you.
koe, Mr Clendon.
Sir, as we begin the rather significant task of working our way through this document, this mammoth document, I think, and in fact my Labour colleague is somewhat mistaken in his count. If one actually looks at the total number of pages, they number to 1,238, including preamble. So it's a little bit of homework for us over the holiday break, I suspect. This significant document, and significant not only in size, but in scope and indeed in what it sets out to do, began its journey. It's an output of a process that began around 3 years ago. The Law Commission, given the task of looking at our court system, a review of that system, and out of that came an excellent document in November 2012, a review of the Judicature Act, and that has clearly provided the basis to a large extent for the development of this bill we're looking at today. The task essentially that the Law Commission was given was to consider the consolidation, the amendment and modernisation of the various pieces of legislation and processes that we have found a way into this bill. And clearly there was a need for that. The point's been made that the Judicature Act itself, being well over 100 years old, that almost predates radio, it definitely predates television. The world has moved on, and of course the legislation needs to catch up. It's interesting that in the terms of reference, the task that was given to the Commission, it was specifically directed them not to consider major matters of policy, the structure and character of existing trial and appellate courts. And I think that's interesting. I don't suggest that they ought to have had that included in this task. I think they've had a sufficient task. But to me, that's shorthand for suggesting they were not required, in fact, were required not to consider, for example, whether our courts should move from an adversarial basis through to a more inquisitorial model, recognising that you seldom get pure models of either. But I think it's a conversation that is abroad. Increasingly, we're starting to hear the discussion evolve that perhaps it is time to consider where we ought to make a transition from what is predominantly adversarial through to a more inquisitorial structure or process for our courts. Putting that aside, there's some comfort, I think, in the fact that this bill is clearly focused, and all of the documents have contributed to its preparation. The one word that consistently jumps out is accessibility. I think everybody sees value in increasing the accessibility of our courts and to the law, to legal processes. That's got to be a primary objective, a driver of all that we do from here on in. The point's also made that clarity is a necessary precursor to achieving that level of accessibility. Clarity about such things as jurisdiction, about the operating characteristics of the court, the processes. Clarity is an important subset of accessibility, and to the extent that that is also addressed, I think it would help deliver a very good outcome and a better overall model for us to operate within. So to speak briefly to a number of the specifics of the bill, it of course creates a single statute that will cover arrangements to all senior courts, and similarly a single statute to look after the district courts and within that the tribunals. One of the interesting things it proposes to do that will impose a duty on judges, a requirement to do things such as publish information relating to the delivery of reserve judgments, recusal from cases, the suitability of judges holding employment or other office while operating as judges, and that all final written judgments, unless there is good reason not to, will be published. And that's a point I'll return to. There's also a requirement for the Attorney-General to publish the processes followed when making judicial appointments, and I think that's a very healthy contribution to transparency. The obligations, the extra obligations placed on the judiciary do inevitably raise the perennial question of where is the line between requiring accountability from our judges, but also protecting the independence of the judiciary. And we know there's a very bright line between the role of this Parliament, the role of the judiciary, and we need to preserve and maintain that bright line. I'm aware that in the review document there was a proposition that perhaps judges should present annual reports, in a sense, of their various actions, and that was the pushback from the judges, I think quite fairly, was to suggest that might be, given that those reports would be to Parliament, that might be perhaps compromising that bright line between the relative jurisdiction of the courts and the Parliament. So I do foresee some rather interesting conversations. The Law and Order Committee, in fact, has recently had some useful dialogue around the issue of judicial independence compared with parliamentary jurisdiction, and I think that will contribute to that indeed. So we're particularly interested in the move towards enabling the use of technology, the proposition of electronic courts and tribunals. I made the point earlier that, yes, 1908 is a very long time ago. It's time we caught up with the 21st century. But like all technologies, we agree in principle with moving, obviously, to an electronic-based and e-based system. It's simply inconceivable that one would not make some moves in those directions. But the adoption of any technology or the making any technology more pervasive always carries with it a level of risk, the risk of unintended outcomes, unintended consequence, some of which could be negative. And I think we do have to be aware, and I'd have no doubt that the Select Committee will think that one through very carefully. It's interesting in the bill itself, it suggests that the following principles need to apply in terms of the use of electronic and technology generally, that all persons should be able to deal with courts and tribunals in a technology-neutral way, and I think that's quite an interesting phrase, and one no doubt will unpick at the committee. The principle is that electronic technology should be used, and should is quite a strong word, clearly, where it reduces costs, speeds up service delivery, makes information more accessible. Those are all things, all good things, but I would also say that I think reducing cost at all cost, at any cost, would not be desirable. The final point made in that part of the bill goes on to say that access to justice should be preserved for all persons, including those without access to electronic technology. And I think that's a necessary protection to put in there, because all of us on a day-to-day basis probably have more electronic toys and tools than we can comfortably use on some days, but that is not necessarily the norm. So as we shift to enabling more use of technology, electronic filing of documents, all the rest of it, I think those are positive things, but we do need to be aware that they could come with some fishhooks. One of the fishhooks, the potential fishhooks that the Greens particularly will be interested in, given that we are encouraging judges or requiring them to post all judgments online, we just wonder how that will rest with the provisions of the Criminal Records Clean Slate Act, which was one of the legacies of a former Green MP, Nandor Tanchos, unfortunately often best remembered for his appearance, but he made some significant contributions to this place. The Clean Slate Act is a piece of legislation that enables people to leave their past behind them. If people make a mistake, they fall foul of the justice system, but then go on to lead good and positive lives, it's appropriate they should be able to leave that past in the past, and that they should be able to just let it sit there. As soon as one puts anything online, of course, you know there are serious difficulties about erasing that electronic trace. So we will be looking very hard at and requiring, in fact, that the legislation ensures that posting judicial decisions online does not compromise the intent or the letter of the Clean Slate legislation as it now stands. So I'd like to say that I look forward to the Select Committee wholeheartedly working on this bill. I think the scale of the task will be, perhaps it's this time of year when we're all feeling rather tired, but perhaps the task is looking larger than it will be. But it will be interesting, it's necessary, it's a good time for it to happen, and we look forward to that ongoing work. We will be supporting this legislation. Kia ora.
I call the